Greetings everyone. We are still making an attempt on answering legal questions. Answering legal questions and approaches to different legal questions. How would you approach them? Question number 1. We discuss the different ways of resolving disputes in Uganda. Approach. Look at the different ways of resolving disputes through defining them and also explaining their procedures, highlighting their merits and demerits. Yeah, that is basically the approach to that question. Now, it is a discussion question. And the question is saying, discuss the different ways of resolving disputes in Uganda. Literally meaning that there are different ways. And the examiner wants the student to discuss all the different ways of resolving disputes in Uganda. That is why in our approach, I am telling you to look at the different ways of resolving disputes. You define them. After defining them, it is important for you to explain their procedures. How do they operate? And thereafter, you will talk about their advantages and disadvantages. Very important. Now, the different methods include 1. Litigation. So under litigation, you are expected to define litigation or taking a case to court. How would you take a case to court? It is very important for you to explain to the examiner what litigation involves. After defining what litigation is, you explain the procedure of litigation to the examiner. After explaining the procedure of litigation and what it involves, of course it involves coming up with a plaint or a document where the aggrieved party comes up with his or her cause of action. After coming up with the cause of action, it is important for the aggrieved party to know in which sect of the law the cause of action arises or originates from. It could be a land issue or business issue. Now, when you get to know that, it will give you a fora on which court you can go to. That is what is involved in you coming up with the procedure of litigation. Thereafter, you'll come up with the advantages of litigation and disadvantages of litigation. And then you'll come up with a conclusion. And of course, there are other ways of solving disputes without necessarily going to court. And that is what we call alternative dispute resolution. Now, when you're answering that question, you'll have to define what alternative dispute resolution is all about. Thereafter, you'll have to state the different ways of alternative dispute resolution. Now, of course, these include arbitration, negotiation, mediation, and conciliation. And then you will come up with what we call conclusionary remarks. Of course, when you are explaining every one of those alternative ways of solving disputes, it is important for you as a student to define, for example, to define what arbitration is, what it involves and how it is done, and then you state the advantages and disadvantages of arbitration, and then thereafter you come up with what we call conclusionary remarks. Question number 2. Discuss the sources of law in Uganda. Discuss the sources of law in Uganda. How do you go about such a question? Of course, you define law. What is law? After defining what law is, you go to defining sources of law. Where can I get laws if I'm looking for them in Uganda? Where exactly can I be able to get the different sources? Of course, after defining sources of law, you define the different sources of law. Discuss how the said sources of law have become sources of law in Uganda. And of course, there are different sources of law in Uganda. We have primary and secondary sources of law. Now, primary sources of law include cases and statutes. And under statutes, we have what we call principal laws and subsidiary laws. Principal laws, like the Constitution of the Republic of Uganda, that is a principal law in Uganda. Then when it comes to commission of offenses, there is the Penal Code Act and other laws which are additionally to the principal laws, and those are what we call subsidiary laws. And then still under primary sources, we have what we call cases. Cases are already decided matters that may be based upon by magistrates or judges in deciding a new case. Cases may be binding and persuasive. So that is what falls under primary sources of law. And under secondary sources of law, we have books, we have journals, we have the encyclopedia, we have dictionaries, and also case books. Then we have what we call applied sources of law in Uganda. And these were mainly brought by our colonizers. We all know that Uganda is a common law abiding country, which literally means that Uganda was colonized by the British. So the British, when they colonized us, brought their laws which became common to us. Thus, they being the sources of common law and doctrines of equity. Another source of law in Uganda is custom. And this is through trade usages and practices. For example, circumcision of the male in Bagishu is a law because it was found out that circumcision is a benefit to the male and is not contrary to any particular act, any particular article in the Constitution of the Republic of Uganda. And then we also have the internet as a source of law in Uganda. Question number 3. Discuss the court system of Uganda. How do you approach such a question? You begin by defining a court system. Defining court system. What is this thing called the court system? And thereafter you discuss the different courts in Uganda and their applicability. Of course, court system is the same as court structure, and then you will begin by defining and explaining the different court structures or court systems in Uganda, beginning from the Supreme Court. How does it operate? Which matters does it handle? Who heads the Supreme Court? He heads the Supreme Court together with who? And then what makes it the Supreme Court? And then the Court of Appeal, you still adopt the same procedure as I stated in the Supreme Court. And then the High Court, the High Court, you don't forget that it's the court which handles all matters in Uganda with the exclusion of constitutional petitions and presidential petitions. And then you also talk about magistrate courts, local council courts, quasi-judicial bodies, which include tribunals. And the fourth question, define a contract of sale of goods under the Sale of Goods and Supply of Services Act. Approach. You define a contract of sale of goods, look at the different characteristics in the definition of a contract of sale of goods, define goods, and then come up with a conclusion. Of course, an attempt of answering that question, you define a contract of sale of goods under section 2.1 of the Sale of Goods and Supply of Services Act of 2018, and then from that definition you'll be able to get the different elements of a sale of goods contract. So you'll define goods, specific and unascertained goods under section 1 of the Act. You define parties, that is the buyer and seller, and then the subject matter under section 6 of the Act, the price under section 9 of the Act. Question number 5, state the rights and obligations of parties to a contract of sale of goods under the Sale of Goods and Supply of Services Act. Approach. This is a straightforward question that limits the students to stating the rights and obligations of sellers and buyers. Duties of a seller. That the seller has a right to sell the goods, section 13. That the goods correspond with their description. That if it is a sale by sample, that its goods should be as described. That the goods are of merchantable quality. That the goods which are bought for a particular purpose are reasonably fit for that purpose. Duties of a buyer. The duty to pay for the goods, and also the duty to accept possession of the goods under section 35. Now, what I've discussed with you guys is basically sample questions. There are a number of legal questions. You don't have to limit yourselves to what I've talked about. I've basically just provided a guide on how any person who is answering a legal question is supposed to approach that question, and how he or she can be able to resolve that particular question. Of course, there are so many other questions which I've not talked about, but I've limited myself to those to act as a guide to any scholar who is about to attempt a particular legal exam. Thank you.